There's a song that says, all we do is win, win, win. And we have another victory for the Second Amendment. So let's go ahead and jump into it and talk about it. We are back live, and thank you for everyone for tuning in. I am joined by the Flying One, Flying Rich. I am back in the country. As you can see, I'm back in my studio, and today we're going to be talking about what is going on out in New Mexico. There is a case called Ortega versus Grisham. Grisham is Michelle Wuhan Grisham, who is the governor of New Mexico, and she really, really hates guns. There was a case challenging the state's 7-day waiting period to purchase a firearm, which I believe a right denied is a right delayed. I mean, right delayed is a right denied. And the plaintiffs, all Samuel Ortega and Rebecca Scott, both believe the same thing. So they sued New Mexico, the governor, over the 7-day waiting period, claiming that it violates the Constitution of the United States. So this is a victory. Rich, thank you for joining me.
You're welcome.
And with that, let's go ahead and get into this document. It's not really long as a court document. Usually court documents are a lot longer. This is 51 pages. So we're going to go ahead and get into this. And I will go ahead and also paste the link down below for anyone who wants to read it themselves. I always encourage people to read everything for themselves. And I just want to point out something. Look who filed an amicus brief in this. Grady Giffords anti-gun sites. All right. So this is in front of a 3-judge panel in the 10th Circuit Court of Appeals. And basically, I'm just going to give you a little rundown on the law. In 2024, New Mexico passed what they called a cooling off period, which says that when you purchase a firearm, you have to wait 7 days before you pick it up. So basically, you go to the store, you buy that firearm, you have to come back 7 days later and pick it up. We have seen that could lead to tragedy, as it did in New Jersey, where a woman was being stalked by an significant other. She went to get a gun because she believed that the guy was going to kill her, even though that there was a
court
trading order against him. He said, "Hey, he's going to ignore that." The court said, "Well, you still have to wait." So she waited, and before she had a chance to get a gun that would give her a fighting chance, he killed her. So the plaintiffs wanted to say, we never want that to happen to anyone in our state or in the country, really. And they said that the law requiring waiting periods violates not only the Second Amendment, but also the 14th Amendment. And at the district court level, the district court found for the state and the governor of New Mexico. So basically what the court is doing is it's reversing the decision, which says your stuff is out and we are sending it back down to you to issue a decision with what we're saying here, which basically says give them the injunction. So the first part of this just goes through the law, the reason why they said the law is passed. Then it talks about Paul Ortega, Mr. Ortega, who is also a retired cop, tried to buy a gun, and Rebecca Scott, who also tried to buy a gun right after the law passed. I think it was the day after it passed. I wasn't sick. I was I was on vacation. And was denied getting their gun hearing right away. So I told you how the district court said that the state was right, blah, blah, blah. And now let's go ahead and get into what the circuit court had to say, the three judge panel for the circuit court.
So, modern doctrine on the right to keep and bear arms is shaped in large part by the Supreme Court's decision in District of Columbia versus Heller, who I was hanging out with Dick last week, which recognized an individual's Second Amendment right to possess firearms, but the right secured by the Second Amendment is not unlimited. From Blackstone through the 19th century cases, commentators and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose.
What they're talking about is the Scalia thing. Scalia said that, like dangerous and unusual weapons can be banned. In the Heller decision.
This case represents the efforts of many states and courts to discern the Second Amendment's outer limits.
So I'm just going to go over the preliminary injunction standard. You need a couple different things to get a preliminary injunction, which is what they're trying to get. First, you have to show that you have standing, which they do. Then you have to show that you are likely to succeed on the merits of the case, which means that the final decision will most likely favor you. And then you also have to prove irreparable harm. Irreparable harm is an interesting thing because it is harm that cannot be rectified with money. Now, if you have your rights violated, the courts have held that can never be rectified with money. So therefore, it is irreparable harm. And the balance of interest has to fall because they have balance of interest has to fall for the plaintiffs. And the balance of interest for the public is always on having rights and not having unconstitutional laws. Then here it's going to go into the text of the Second Amendment because we start with a Bruin analysis. It just says our Second Amendment analysis, but what they're talking about is Bruin. Now, Bruin pointed out a couple of different things. First is the plain text of the Second Amendment. Mr. Ortega and the woman, can't remember her name, I'm sorry. I just went blank on her name for some reason. But Mr. Ortega and the other, Miss Scott, basically are both over the age of 18 and part of the political class. If you're part of the political class, which the courts have said over the age of 18 is part of the political class, that means you are part of the people. I think you could go lower, but the courts are pretty firm on 18 to be part of the political class. So that makes them the people. And the stuff that is in question is handguns and all the guns, which are bearable arms, which satisfies the right to bear arms portion of the Second Amendment. So just wanted to explain that a little bit quickly here, just to let you guys know what is going on. Now, after it's determined that they are part of the people and the arm in question is protected, it falls over to the states or the government, whether it's federal or state government, to provide historical analogs to prove that the current law is consistent with the nation's tradition and history of firearms regulations from the founding era, which is usually considered 1791, the ratification date of the Second Amendment, although some leftists and some anti-gun people try to push it to 1868 during the period of Jim Crow, the ratification date of the 14th Amendment. In Rahimi, which is another case, it said that a historical analog does not have to be identical, but it has to be remotely similar. So just giving you that right there. But so basically, they're just following that. They talk about borrowing here, all that. So let's just go down to the first consideration.
Our first consideration is whether the Second Amendment's plain text covers the conduct curtailed by the enactment as informed by history, Bruin. If it does, then the Constitution presumptively protects that conduct. Common sense dictates that the right to bear arms requires the right to acquire arms, just as the right to free press necessarily includes the right to acquire a printing press. Wow, that's based. Or the right to freely practice religion rests on the right to acquire a sacred text. Legal interpretation
follows common sense. All right. So what the antis tried to do for a long time is says you have the right to bear arms, but you don't have the right to acquire arms. The court over and over and over again have rejected that argument because without the right to acquire arms, there is no purpose to have the right to bear arms. And what they are citing here, or what you call base, is free press is the right to acquire a printing press or to practice religion requires sacred text. That's used in a lot of courts. And that's basically the law of the land at this point. I don't really think the Ninth would disagree with that. And they haven't.
When a text authorizes a certain act.
This basically just is going over that.
Okay.
Basically, it's in. So basically, it compares paper for computer to the right to print, the ability to own property, predicates the right to confiscation in the takings, because they have the takings clause, but I'm not going to get too much into that. So basically, just states that that the right to acquire arms is part of the right to bear arms.
New Mexico argues, however, that the waiting period law does not implicate the ability of anyone to keep and bear arms, at least not directly. Instead, it argues that firearm possession is a distinct form of firearm sales and transfers. According to New Mexico, the Second Amendment's plain text does not cover acquiring or purchasing firearms, especially immediate acquisition of purchased firearm. Yet New Mexico acknowledges that severe or abusive limitations on acquisition would be a burden the Second Amendment, and the waiting period here survived because the burden is minimal. So by New Mexico's illogic, a restriction on a firearm sale does not burden the Second Amendment until it does.
Basically, what they try to argue, because I listened to the oral arguments in this case, what they try to argue, well, if we made the waiting period a year, that would be unconstitutional because that's too long. But the burden is only a slight burden, therefore it survives.
As my favorite analogy, you can ride the bus just in the back.
Yeah. So basically, the court's rejecting this. Keep on going, Rich.
And where are we? The argument provides no limiting principle. It inevitably leads to a case-by-case judicial interest balancing. But the Supreme Court and the Constitution reject the notion that the right should be restricted simply because the government believes its interests on balance are more important than the individuals, and it cites Heller.
Yeah, Heller said that, and Bruin doubled down on that.
Mm-hmm. We know of no other enumerated constitutional right whose core protection has been subjected to a freestanding interest-balanced approach. The very enumeration of a right removes it from the judiciary's power to decide on a case-by-case basis whether the right is really worth insisting upon. Wow.
Yeah, Heller pointed that out, and remember Thomas said the Second Amendment is not a second class right, and they got rid of intermediate scrutiny, which is also known as interest balance.
New Mexico's argument that limitations on firearm sales or transfers do not implicate the Second Amendment's plain text is wrong, and the district court's engagement in limited means and scrutiny is also wrong.
Yeah,
The
they use
district court's
means and scrutiny, and according to Bruin, they're not allowed to use that.
the district court's analysis crediting what it saw as a minimal burden circumvented Heller, Bruin, and Rahimi, landing right back at the freestanding interest balancing approach that those cases explicitly rejected. And
All those cases made it clear that there is to be no more interest balancing.
So I'm going to skip a lot of the citations. Judicial deference to constitutional.
Yeah, you can skip all that. Let's go down there.
Another court also faced with the assertion that keeping and bearing did not include acquiring when considering a waiting period. Law post Bruin Rahimi also rejected the argument. It stated if a citizen cannot take possession of a firearm, then his or her right to possess a firearm or carry it away is indeed curtailed, even if the state claims that the curtailment is modest. However, the threshold inquiry is whether the Second Amendment covers the conduct curtailed by the act, not a qualitative assessment of how modest the imposition on the right happens to be. That is indiscriminate disposition, plain and simple. Wow.
Yeah, basically, they come on to say like a blanket pulling off period or waiting period is unconstitutional.
The burden imposed by a cooling off period is brought into sharper focus when considered in the context of other constitutional rights. A carte blanche 1 week cooling off period to publish news stories? Oh, okay, I understand where they're going. Unconstitutional. United States versus Quatrain.
Okay, basically, then go into the COVID stuff where the Catholic Church had to sue to get their churches back open as well.
A prior restraint is not constitutionally inoffensive merely because that is temporary. Temporary closures of churches during COVID, unconstitutional. Catholic Church. Cuomo. Yeah. Oh, good, right?
You can go down to here. If
Elrod v. Burns, if a criminal defendant had to wait 30 days after his arraignment before he could seek legal counsel, so he would not unduly resist his prosecution, unconstitutional, of course.
So basically, it's saying, look, with all these other cases, all these other constitutional rights, we say a right delayed is a right denied, and they're basically saying that it's the same thing here.
Mm-hmm. As a general matter, the government cannot delay the exercise of a right because it believes that the citizens might misuse it without sufficient time to reflect beforehand. Denial of cert.
Just go our law.
Our law rarely generalizes the potential for abuse. It requires an individualized assessment. In short, regardless of paternalistic intent, waiting periods burden the right to keep and bear arms. But Heller also carved out certain laws from exacting historical scrutiny that followed in Bruin and Rahimi. Heller declined to examine longstanding prohibitions, including laws imposing conditions and qualifications on the commercial sale of arms. In a footnote, the court referred to these as presumptively lawful regulatory measures. Those laws were supported without any explanation of how they would fare in light of the Second Amendment's original meaning. And I'm going to skip. This summary treatment foreclosed the possibility of more sophisticated interpretation, despite the lack of an explanation, despite the passage's status as dicta, and despite the possible tension between Heller's dictum and its underlying holding at 1047. These categories have been carried forward and enmeshed into the Second Amendment jurisprudence. We recently held that some long-standing prohibitions, such as minimum age limits, not only survive Bruin and Rahimi, they also presumptively do not burden the Second Amendment. Rocky Mountain gun owners versus Polis, because the presumptively lawful regulatory measures language first stated in Heller has not been abrogated, it remains good law. Still, courts have only partially fleshed out the boundaries of these commercial conditions and qualifications and other Second Amendment challenges, and we acknowledge the lack of full fleshed out guidance on these safe harbor provisions in RMGO. I don't know what that is.
Rocky Mountain gun owners.
Oh, okay.
That's the case. They're referencing the case. There's a bunch of cases right now that there's one in the 4th, and there's several others, one in the 11th, that is challenging the 21-year-old for handgun.
But even in its murky territory, Waiting Period Act falls far short of a presumptively constitutional law. It is not limited to commercial sales. It does not fit with other known conditions and qualifications in this category. First, cooling off periods are not tailored to commercial sales. They are imposed on many non-commercial transfers, while many commercial transfers are excluded. Heller carved out laws imposing conditions and qualifications on the commercial sales of arms.
Okay, stop right there. Stop right there. Like in New Mexico, if I was to sell a gun to Rich, we would have to go. They have universal background checks, so we would have to go through a FFL. That is a private sale, but there is still a cooling off period. Now, if a gun dealer wants to sell to like the local police department, there's no cooling off period for there, which is a commercial sale.
Mm-hmm. Mm-hmm.
So basically, they're calling it. There's like, hey, this doesn't make any sense. What you're saying?
Gotcha.
Exempting some commercial sales, and then you're reclassifying private sales as commercial.
But the Waiting Period Act does not distinguish between commercial and non-commercial, while the statute refers to only buyers and sellers and seems to exclude gifts. Not every exchange of a firearm is for money or commercial nature. For example, a collector selling firearms to a museum collection must wait 7 days. If a hobbyist with a federal firearms license decides to sell a gun to a friend, he must still wait 7 days. A waiting period cannot solely be a qualification on a commercial sale if it applies equally to non-commercial conduct. True, some non-commercial transfers, such as those between immediate family members, are excluded from the statute. That small carve-out is thin gruel. Other entries in this list of exceptions reveal that many explicitly commercial sales are not affected by the waiting period. For instance, the purchaser with a federal firearms license does not have to wait 7 days. As a result, transactions between manufacturers, distributors, gun stores, progenitor, commercial firearm sales will not be subject to the waiting period, since nearly every firearm bought by an individual in New Mexico must first be sold to a distributor with an FFL. There is at least one explicitly commercial sale exempted for every prospective sale subject to the waiting period. Added to the exclusion for law enforcement agencies and officers who often purchase bulk firearms, at least half of all commercial sales in New Mexico would be not affected.
Yeah, that's what I was
by the Waiting Period Act. Second, the Waiting Period Act does not impose a condition or qualification like other restrictions considered presumptively constitutional. In Heller, the court listed long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms as non-exhaustive list of presumptively lawful regulatory measures. Heller, let's see, in McDonald v. Chicago, the court reiterated that such longstanding regulatory measures were not imperiled by the Second Amendment. And Bruin, in an apparent nod to these categories, the court noted that shall issue licensing regimes under which ordinary citizens presumptively qualify for licenses unless investigations reveal otherwise, are meant to ensure that purchasers were law-abiding, responsible citizens. And that's citing Bruin, because they use narrow, objective, definite standards. They were not constitutionally subject.
Yeah, what the courts have a really big problem with is all this is subjective standard.
But a cooling off period is not such a condition or qualification. Plaintiffs argued that it is not a condition because it cannot be met by any act, and it is not a qualification because it is universally applicable. They are right. A 7-day waiting period is not a condition on a sale any more than the price of a firearm is. The sale happens regardless, and the waiting period is just an artificial delay on the possession. And an act,
the legal stuff and go down to nor is it a qualification. You can just go down to here.
it is not enough that a regulation sometimes affects a commercial sale. A blanket waiting period is simply not of a kind with the condition and qualifications imposed by other presumptively lawful measures. See Bruin. Only narrow, objective, and definite standards, and that's Penna v. Lidley.
The Supreme Court in Heller could not have meant that anything that could be characterized as a condition and qualification on the commercial sale of firearms is immune from more searching Second Amendment scrutiny.
In emphasis added.
Go down to by New Mexico's logic.
Okay, by New Mexico's logic, adopted by the dissent, and outright ban on commercial sales would not be a condition or a qualification on commercial sales and presumptively lawful. Ouch. New Mexico points to a concurrence in a Ninth Circuit court case which argued that California's waiting period is a condition or qualification of the sale of guns and imposes a brief delay to permit compliance with background check requirements and provide a cooling off period as a prerequisite to acquiring a gun. But that view never garnered a majority on any court. The majority in Sylvester instead employed intermediate scrutiny under Heller, an approach later abrogated by Bruin. Rather than help New Mexico, Sylvester shows that the courts have consistently held waiting periods impose burdens on the Second Amendment and not presumptively constitutional.
What they did is they tried to take a dissenting judgment and use that to say, see, another judge out there agrees with us. That's probably the only thing that they had, where the rest...
Another crazy judge agrees?
Yeah, with the rest said that that it is unconstitutional, but at the time there was intermediate scrutiny, so they used intermediate scrutiny to justify upholding the law. Now, if that case went back and they ruled exactly the way they ruled, they would have to rule for the plaintiffs in that case, because they can't use intermediate scrutiny or the Constitution.
New Mexico and the dissent argued that our decision in the, I forget what RMGO, Rocky Mountain Gun Owners, forecloses the conclusion that the Second Amendment is burdened by a waiting period, but we explicitly declined to define the full scope of concomitants rights, if any, to help and bear Rocky Mountain Gun Owners. We resolved that the case instead by concluding that limiting firearm sales to those over 21 years old was presumptively lawful condition or qualification. The dissent would do the same today, but it does so without any consideration for what defines a condition or qualification on a commercial sale. It is content to assume that any law which regulates only the selling and purchasing of firearms is presumptively constitutional. That shortcut analysis could prop up laws that lay heavy burdens on the rights of ordinary citizens without a glance at whether the supposed conditions or qualifications is any way like others given safe harbor.
Okay, then I'm going to skip a bunch of this. Basically, they're saying that what was argued in Rocky Mountain gun owners and what was argued here are two different things. But and this is funny. They say, well, even if we did think that Rocky Mountain gun owners case and this were related, it still would not give you the victory, and you would still lose. Now we're going to get into where the burden falls on the state to provide historical analogs.
Fit with historical tradition, outside the presumptively constitutional exceptions, the validity of laws that fall under the Second Amendment's text is determined by historical history and tradition. In Bruin and Rahimi, the Supreme Court instructed lower courts to follow an originalist methodology in conducting this inquiry. In doing so, we examine our historical tradition of firearm regulation to help delineate the contours of the right. Rahimi, if challenged regulation fits within that tradition, it is lawful under the Second Amendment because the laws may infringe on constitutional rights. It's the government's burden to justify its regulation. To meet this burden, the government must show a well-established representative principle derived from the history and tradition that would inform the text meaning. Modern restrictions must be relevantly
I went over all this.
similar.
I would have to be a dead ringer, but it has to be similar.
Why do we?
But then it goes in why they need that. But so just go down to here.
First, we reject the notion that other waiting period laws themselves carve out a historically grounded principle. They are mostly a modern innovation. The New Mexico points out that the Waiting Period Act's historical pedigree stretches back to 1923, but that
which is way, way far away from 1791. Go ahead.
That is an oversimplification. True, California's imposed one day waiting period in that year intended to give officials time to conduct a background check. And cites Sylvester. A few states followed suit over the next few decades, but those early examples are easily distinguished from this one because they were explicitly tied to the time it took to conduct a background check. Until the 1990s, no waiting period was required a prospective buyer to wait longer than was necessary to conduct a background search. Federal law briefly required universal waiting period during the completion of a background check from 1993 to 1998, Brady Handgun Violence Prevention Act, but Congress sunsetted that law from the start, and that waiting period requirement lapsed when the federal government implemented the National Instant Background Check System, 1998.
Yeah, so they're saying that there was a background check system in 1993 to 1998, but that was because NICS didn't exist.
The first state waiting periods that were untethered to the time it takes to pass a background check or complete certification course did not appear until the 1990s. Sylvester v. Harris. Even now, only about a dozen states impose waiting periods of some kind. Given the few states in which they have persisted and the duration of waiting period laws cannot satisfy the government's burden in Bruin, today's decision should not be understood to endorse freewheeling reliance on historical practice from the mid to 19th century establishment of the original meaning of the Bill of Rights. Any innovations of mid to late 19th century come too late to provide insight into the meaning of the Constitution in 1787.
So basically, they're saying that the stuff that they gave for their historical analogs was way too young and doesn't go far enough. And then what they always try to do is they always try to throw in a bunch of different laws. Like, for example, they try to use like intoxication laws, like laws that said you can't be armed with a firearm while intoxicated to justify their bans. And they always bring up the targeted group bans, which are the racist gun laws. It's funny how they always go back to the racist gun law.
Don't you think there would be such a stink attached to that nobody would reference it?
Well, that's all they have. I mean, all gun laws are racist, right?
Democrats were racist once upon a time, and we still are.
Yeah.
In Bruin, the court rejected the government's attempt to characterize New York's proper cause requirement.
It's just going to go here, and it breaks all the laws down and says why they don't apply here, which should be pretty obvious. But yet here we are again. Just go down to scope of
Injunctive relief. Finally, a word regarding the scope of relief sought by the plaintiffs. The plaintiff requested both facial and as-applied injunctive relief. Because the district court did not grant any relief, it made no findings about the proper scope of any injunction. We remand so that it may do so now. It is the general rule, of course, that federal appellate court does not consider an issue not passed upon below, and citing case law, while the parties.
Okay, let me explain something. Since the district court didn't decide, they can do an as applied to the defendants or overall to everyone. And in that circuit, I guess now. So they're telling the district court that they have to consider that and rule on that. Technically, it should be a facial permanent injunction, like preliminary injunction, because it applies to them. It's going to apply to everyone. So that should be what we get out of that. But I would not doubt that the district court nubs its nose and says it's as applied to defendants only, or these plaintiffs only.
Indeed.
That's
cool. And maybe we get rid of waiting periods in Florida also.
There is a challenge to those. There is a challenge. All right. So that is definitely good news here. It's another victory for the Second Amendment. We have been racking those up a lot, and it is driving the antis mad. I remember a posting by Everytown, like before Bruin, and it goes, the only thing that the pro gun side is good at is losing in court. How does it feel now? That's all I got to ask him. How does it feel now? Because we might have lost it with a lot of activist judges, but we will win when it gets to the Supreme Court and Circuit Court. Those cases just had to make their way up.
Amen.
But yeah, that's it. That's it, basically, guys. Just wanted to bring you everything that is going on. I have some exciting stuff coming up. It is a really interesting interview that I'm going to be doing. Can't let too much onto it right now, but it's going to be interesting. Stay tuned for those. Actually, two. One is a guy running for Congress as a Republican in a 90% congressional district. So pretty sure we're going to be talking to a future congressman on that. And the other one, I got to keep quiet for now, but it'd be
very cool.
Interesting. with that, we're going to get out of here, guys. Thank you so much for tuning in. As always, stay safe out there and keep your gun on you. See you guys later. Bye.